Welcome back to Advocacy Alchemy with Professor Ross. I am Professor Ross, and I want to welcome you back to class for this evening. We have 3 different videos, and we'll lecture on each one of these videos. I have a person who assaults an officer, who punches an officer. I have a bond that is argued to be reduced in a interesting fashion. It was a good argument and it was good advocacy. However, the judge was on his toes and ruled not in the favor of the good attorney. All right, we'll watch that one first, and then finally we have a last video of a search that is quite interesting. So the last video we watch will be about a search incident to arrest, and we'll talk about that more when we get to it. All right, so sit back and enjoy. We'll learn as we go. We'll watch some various different videos from different people. And if you have any questions or comments, put them down below. Like the video. Go back and watch the older videos. And really try to get in my groove on how I'm going to deliver this content. Focus here is for your education at large on how to interact with the justice system in a sensible manner. All right, I always advocate for allowing a professional to do their job. So with that, if you are going through any situation where you need legal help, seek out the help of an attorney. All right, in the meantime, for those who wish to one day become an attorney or to work in the court system, become a police officer, court security personnel, trial court administrator, let's jump in. All right, so we'll be using this search feature from ChatGPT. This is basically their Google. They are releasing this. It may be available for everyone to use now, but basically it's just a search engine. It allows you to type in what you're looking for, just like on Google, and from there it will pull back instead of giving you various different websites, it gives you sort of your answer and where you can find it on various websites. So it gives you your answer back in a couple of paragraphs, each paragraph cited to a different website, if that makes any sense. All right, if you haven't seen this in use before, we'll put it into action here in just a moment. All right, so let's jump into our first video. Remember, this is a bond. So someone asked for a bond for someone who's in jail, and that's a good place to start. Let's look up the term bond in a criminal case. Understanding bail and bond in criminal cases. All right, in criminal cases, a bond, also known as a bail, is in my home jurisdiction, we use bail bondsmen who put up a surety bond for a person to be released. All right. Here, it's telling us about, in general, the concepts of bail and bond, and it's saying a bond is a financial guarantee that the defendant will appear in court when required. That's the key reason why bonds are issued, or why defendants are given a bond and allowed to be released by putting up a sum of money. And so they can be assured that they'll come back and face whatever charges are being alleged. Okay? If a defendant fails to appear, the bond is forfeit and a warrant for their arrest may be issued. The bond amount is typically set by a judge during a bail hearing. All right, so typically there's a special hearing for this, but it can happen at the conclusion of any of the initial proceedings. So whether it be the first appearance is happening within a set period of time after a person has first been arrested. All right, also can be paid in various forms, such as cash, property, or a surety bond. All right, so that's enough initial information, and it'll be on the screen. We'll scroll it here just so you can see the different forms of a bond that a person can put up. And let's move on to our first case. Let's move it to maybe this one. And I think it's big enough where you still can see. And all right, let's jump into this. This is from Courtroom TV. The title of their video is "Fired Up Lawyer Fights to Free a Monster." All right, $1 million bond is what I put on this clip. Let's watch this short clip, and then we'll watch the short hearing they have here. All right.
A $1 million bond is traditionally reserved for homicide cases, Judge. In this case, in this particular case, Judge,
not in this county, but go ahead.
Thank you, Judge. Respectfully, Judge, we're just asking for a fair, reasonable bond that will ensure that this young man comes back to court, which I'm confident he will, number one. And number two, ultimately, that they don't have any communication.
Have you read through the discovery thus far?
A $1 million bond is
So that's Judge Cedric Simpson. This is out of Michigan. So let's look at some bond requirements in Michigan. So we'll look up this search. In Michigan, which is MI, when is a bond usually set? Okay. All right, so the bond is usually set at the arraignment in Michigan. It says a bond is usually set during the arraignment, which is the first court appearance after an arrest. This typically occurs within 24 to 48 hours of the arrest. All right, remember, here we're going to view the laws that are in effect in the places where these videos are actually taking place. So that's a key thing, and this is just to show you that these same advanced legal research methods can be used anywhere. And it's to your own benefit to take up some of these skills and learn how to use them. And as we dive deeper and take looks at the actual laws, that you educate yourself on how to view the law, but you always remember that you can always go to an expert, a lawyer, to assist you with your own situation. And that's usually how you'll get the best outcome. All right, but once again, back into a bond. We see the bonds are usually set 24 to 48 hours after the arrest. During the arraignment, the judge will read the charges against the defendant, inform them of their rights, and set a bond amount. All right, they talk about the different types of bond, which we already have up here. So I'll scroll that back up. And let's get back in. Let's watch this.
Traditionally,
All right, and this is about a 9-minute video. We'll stop throughout and
Report, Edward Martel, P. 85051.
Why is this?
On behalf of Mr. Timothy Cunningham, who stands to my right. Sir, please state your full name for the record.
Timothy Cunningham.
Thank you, sir.
Thank you, Judge. Today's date and time for probable cause conference, just recently retained, have touched base with sister counsel, have requested discovery. My client's been fully advised of his constitutional right to an examination within 21 days, considering the recent retainment as well as the.
okay, so first of all, that is sort of a difference when you have a private attorney versus having an attorney that's assigned to this division and constantly here working and working and working. This attorney came fired up, but sometimes you have to be a fiery advocate for your clients because of the nature of the charges they're facing. Okay, you see the judges, he's actually giving, and you all can go back and watch again how the judge's reaction is. And you can go find many of this judge's videos since he does a lot of his circuit is done with Zoom hearings. All right, notice this guy here is not a part of this hearing. He's waiting on his turn, which will probably be next in line. Or he might even be a bondsman. Let's see, we don't see.
The discovery issues.
Let's see if we can see what exactly his. Well, no, he doesn't have a name here that says Motorola Moto. So I'm guessing he's just another person waiting on his case to be called. But let's continue to listen here and see what all he has to say.
At this time, he's wishing to waive the 21-day rule and set this and respectfully ask this honorable court to adjourn a probable cause conference for a period of around 2 weeks, Judge. Please and thank you.
2 weeks. That objection, probable cause, September 12, 2024, 9 a.m. bond continued.
I'm sorry, Judge.
12th?
9/12,
Yes.
10 a.m.
Okay, so one thing about these arraignment hearings and these first appearances and the initial hearings before discovery is turned over in a criminal case. This is what this is. This is a criminal case. Something's going on here. You see you have officers in the background standing and waiting on this defendant who's in custody. He has the jumpsuit on. He has shackles on. And he's going to be escorted back to the jail portion once he's done, or back to the transport area where they keep people before they transport them back to jail. All right, so usually these are fairly uniform. The judge either reads the charges. In this instance, they have waived the reading of the charges. And that can be done also. It just simply says that we don't need the charges read again. We know what they are. We wish to enter our plea of not guilty and go ahead and get set on your jury docket. And that's basically essentially what he said here. And he's ready to come back on his next set of hearings in about 2 weeks. I think he said they're probable cause.
At 9 a.m.
9 a.m. Judge, may I briefly address the issue of bond?
Sure.
Thank you. Judge, as this honorable court is aware, bond is not meant to be punitive. The current bond is $1 million cash. Bond is certainly not meant to be punitive. It is meant solely for flight risk and danger to the community. And the court must consider both.
Okay, so he accurately pointed out exactly what bond is meant for. It's meant to assure a person is going to appear back when they're supposed to, and it's supposed to make sure that a person does not flee, and also that the person won't pose a significant risk to the public at large, society. Okay? Listen to him. He's cooking.
If it is meant solely for flight risk and danger to the community. And the court must consider both the history of the offender and the nature of the allegation, Judge. In this particular case, we have a young man with no prior felony convictions, no prior domestic violence history. We have two individuals that have a child.
Okay, so you might wonder, why is he going over his history, whether he has a criminal history or not? These are all factors in determining a bond. Let's come over here and let's look that up. All right, NMI factors for bonds. Okay, so it says in Michigan. In Michigan, in Michigan, judges consider several factors when determining the bond for the defendant. These factors include the severity of the offense. All right, so we're going to get ready to hit this in just a second in this video. The risk of non-appearance, that's flight or to flee the jurisdiction. Danger to the public, criminal history, ties to the community, flight risk, financial status, health and safety, cooperation with law enforcement. And then you have conditions of your release. All right, so you see a couple of these kind of happen. So risk of non-appearance and flight risk are very much kind of the same thing. All right, it says the possibility that the defendant will flee the jurisdiction. All right, and risk of non-appearance is the likelihood the defendant will fail to appear in court when required. So this one doesn't necessarily mean he leaves the city or county where the action is happening. This just means they won't come back. All right, the severity of the offense means the nature and seriousness of the crime committed. So what level of crime was committed? How dangerous was that crime? What were the circumstances for that crime? A person's criminal history, their prior criminal record, ties to the community, their connections to the local community, such as family, employment, and residence. This is an important one because what this looks back is to the old ideology of shaming a person. If a person has a bunch of ties to the community, they're going to show up to try to clear their name because otherwise they may be shamed in their own community. All right, so this comes up sometimes. All right, financial status, the ability to pay the bond. So when you have a rich dependent, the bond may be higher. Health and safety, the defendant's physical and mental health, as well as any potential safety concerns. All right, cooperation with law enforcement. All right, if a person has agreed to testify on behalf of the state in some larger crime, many times they'll be given a bond. Okay? And then certain conditions of release. Sometimes people are ordered to stay away from certain people or places. Sometimes they're ordered to get on electronic monitoring, whether an ankle or a wrist monitor. Sometimes they have additional conditions to come in and give a sample for drug testing. All right, it all depends. All right, so let's jump back in. Let's see what they have to say.
Out in common, Judge, notwithstanding the allegations, Judge, at this time, the $1 million bond is substantial. He's 27 years of age. Again, no prior felony convictions, no caprious history, so certainly not a flight risk. We're talking about danger to the community. This, again, is not a random individual. The two have a child in common, so we really are talking about purported danger to the current complainant, Judge. Certainly there are mechanisms or conditions or set of conditions which could circumvent any of these are concerns of the court, namely GPS tether, house arrest, Third-party custodian in the courtroom is his mother and his wife, Judge. He is, again, married.
Okay, so notice that, I mean, he's hitting all the points that you would want your lawyer or a lawyer representing someone you know to hit. He's talking about all the things the judge can do in order to try to get this bond lower. And notice in the end, he's going to give a number that he's already talked with his client about of what kind of bond he can come up with, him and his family. All right, so he's offered. He said, Judge, you can put him on a electronic monitoring. You can. We have some of his family members here that can give testimony if you need it right now, so that you know who this person is. So what's happening here is that the judge who lives in this community, works in this community, is a part of this community. All right, he needs to be assured that you're going to come back and stand trial, okay? And his job right now is to look at these factors, all these factors we have pulled up over here, whether a person is a flight risk, their ties to the community, you know, the severity of the offense. All that has to be thought about when the judge is thinking about the idea of bond, okay? Any one of these going wrong for a person can cause that person to have to remain incarcerated until their trial happens.
4 children, 2 of which are autistic, that he is the sole caretaker provider for as far as financials, Judge. If this young man is not released back into the community and allowed to work, frankly, they're going to be homeless, Judge. Not only is he not going to be able to provide for this family, but he's not going to be able to provide for the complainant and her child, Judge. So we're humbly.
All right, notice that he's convincing this other defendant. He's probably thinking, hey man, I need to get this guy's number so I can I can hire him. All right, but listen to him. I mean, he's cooking. He's doing a good job. He's doing a great job. He's dressed in his good suit today. He's probably already got a nice retainer fee for this case so far. So, hey, he showed up. He's ready to work.
Asking for a fair and reasonable bond, Judge, of $50,000, 10%. Again, bond is not meant to be punitive, and that is enough to ensure that this young man comes back to court, 1, and 2, and there's no danger to her. Again, and they've known each other for 15 years. There's no prior domestic violence allegations between the two during that time, known each other since middle school. Ultimately, we're asking for home confinement with permission to go to work, Judge. Please and thank you.
All right, so his argument was just like you would want your argument on paper to be. When you file a motion, in the end, you always tell the judge what you want, what you're looking for, all right? Because people can sometimes get up here and talk for hours and hours, and the judge still doesn't know what exactly is this person asking for, all right? So he told him at the end what he wants. He wants a bond to be set at $50,000, and if he needs a hardship license, something to allow him to be able to go back to work and support those 2 children that are special needs. All right, let's jump back in. Let's see what the judge has to say on the rebound.
Just before I hear a response, I have on the information provided to me, counsel, is that he does have a prior conviction of some type.
Correct. For no felony convictions, no domestic. Is that correct, sir?
Yes.
What was that one for?
I believe it was some type of misdemeanor conviction.
Of assault and.
So you got a prior assaulted
No,
conviction?
He has
No.
a 17-year-old juvenile conviction for assault.
Counsel, I have that his adult criminal history includes at least 1 misdemeanor.
That is
That's what
correct.
I'm asking.
What is the misdemeanor for criminals or for adults, sir? Do you recall?
I'm not sure.
Okay, and also in terms of that, I also have it, and again, counsel, this is the information that's provided
Yes,
to
Judge.
me and provided to that
All right, so we'll pause there right quick and we'll talk about it. So what the judge is looking for is he's looking at his record now. So in front of him is everything that this person has had on his adult record. So he can see that there is a misdemeanor. Now he might not have what exactly the misdemeanor is for, but maybe that there was a conviction or there was an arrest or something on his record. And he's asking about it so that he has a fair opportunity to speak about what happened, whether he went to probation or whatnot. So remember, if you are ever engaging with someone who is involved in the court system, when being asked questions by the judge, do not tell any lies and only give the truth when you're being directly spoken to, okay? Because he's really making an assessment right now on the fly in his head as he's going over this stuff. And that's the last thing you need is a factor of if he catches you in a lie during this 5 or 10 minute interaction, that's going to set the stage for the next few months that you're dealing with this person.
Either from that or from something else, he has 2 previous failure to appears on some.
I was aware of one.
Hold on.
That's,
And I do understand, Judge.
All right, so you heard the person began talking. He began talking to about I believe there was only one. And you see now he's sitting back like, okay, you told me there was only one misdemeanor, but we got these failure to appears. Now that is important at this stage. While it might have been rectified later on, if there are multiple times when he failed to appear back in court, he's in court right now. Do you see the correlation between the two? All right. So he started speaking, and his attorney told him, hold up, let me speak. All right. So we're going to see if he can speak we're going to see where he can speak.
Position of the court. I do have his mother in the courtroom who's contesting same. However, Judge.
okay, that's fine. I'm just telling you what I have.
Thank you, Judge. And notwithstanding same, Judge, there's certainly conditions or set of conditions that can circumvent any of these cares or concerns of the court. Namely, again, home confinement. I don't believe that was ever utilized in the past. Like, he has not one retained counsel, but 2, myself and Mr. Nassar, Judge, we're certainly ready to address this on the merits.
Response from the people.
Judge, we had actually asked for originally a $5 million bond in this case. This is a highly concerning case with the victim.
All right. So key thing, when you're involved in the court system, it's important that you're able to be aware of what's being said in court. So you have to listen closely. You have to watch people. You have to see what someone says. All right. If you're an attorney, you have to be aware of everything that's going on, because everything potentially might be something that you need to object to, or it might be a point in your argument when it's your turn again, because everything works in turns. One side goes, then the other side goes. It's just like a chess match or checkers or any other sort of game you've ever seen. Each side takes an equal amount of turns. All right? For the most part. All right? And we'll get into those as time goes. We'll talk about when things are changed. But listen to what she said. She said that we originally asked for $5 million to be his bond.
Response from the people.
Judge, we had actually asked for originally a $5 million bond in this case. This is a highly concerning case with the victim. Safety. This arises from a relationship between the defendant and victim, where the defendant didn't want the victim to tell anybody that she was pregnant, and literally told her that he was going to beat the shit out of her and beat her up real good and do it in front of the kids. Told her that she was going to slowly cut them all, dragging them just enough to keep them conscious, and pull their nails and teeth out. Then he goes over to her residence. She was in the shower at the time. He went down.
Okay, so you heard the threat. or a summation of a threat that was made to his girlfriend, his pregnant girlfriend, that he didn't want to keep a child that she was pregnant with. All right, that's fairly heinous, and that in a domestic situation can create a case. All right, but not only that, there is actual some physical violence that happens here. So listen to what happens, okay? We're not watching the dash cam footage. We're hearing. So this is when you're a court security or you work in the court system. All right. Remember, you're dealing with everything after it's happened. So you're only taking things based on the testimony of those who are there in court to testify about it, and everything's already happened. All right. You're looking at the old pictures that were taken at the police station. You're reading the medical reports, all those sorts of things. Okay. But listen, understand also where we're at in time. This is only about either a couple of days since this incident has happened, or this is the hearing a couple of weeks after. All right. So let's listen to what's going on here. Listen closely.
Stairs. He starts buzzing, doorbell's trying to get into the apartment building. She's not letting him in. Someone else lets him in. He immediately opens the door, grabs her by the throat with one hand, slams her against the wall, strangling her, and lifting her off the ground. She ended up having to go to the hospital that night, and she had fractured her back. This is extremely concerning in the situation. The prevention fire is and coming over to the apartment and doing what he did to her. I have extreme concerns for this victim and her safety and her children's safety.
Judge, may I very briefly rebut?
Well, I just want to also make sure that there were the back injuries. I see the notation of a fracture to her back. It's also related to the court.
Okay, so you also hear that there were injuries. There was a fracture to her back. She's pregnant. There was a fracture to her back. All right, that sounds fairly serious, okay? Without taking any testimony and getting into who's, whether it's enough for a person to be guilty overall, the judge has to consider this. All he's heard, will the bond remain at $1 million?
Court that the victim at the time could not stand or walk. Is that correct?
Yes, that's absolutely correct.
Go ahead, counsel. Walk. Is that the court that the victim at the time could not stand or walk? Is that correct?
Yes, that's absolutely correct.
Go ahead, counsel.
Thank you, Judge. And notwithstanding the allegations, certainly my client stands.
All right, so you heard the way and you saw the way he told the lawyer, go ahead and say what you're going to say for the record. All right, but that face looks like the decision is probably made. He said, is it his understanding that the victim could not stand or walk after the interaction between herself and her boyfriend? And the attorney for the state, the prosecutor who's sitting over here, said that's correct, Your Honor.
Answer today with a cloak of presumption of innocence over him, Judge. Now, this allegation that never wanted to have the child, they have a child that's 2 years in common, that's 2 years, nearly 2 in common. So that's, hardly irrelevant, Judge, for lack of better terms. And as it relates to the purported injuries, well, one, when the paramedics arrived, whatnot, she was standing there when she was found. So I don't want to get into too much into the merits, Judge, but again, it's flight risk and danger to the community, Judge. There's conditions that could.
Yes, counsel, but what makes it a danger to the community is that when somebody who may be pregnant ends up with a fractured back, and the indication that I have is that she cannot walk or stand, that's a danger.
No dispute, Judge. Respectfully, I don't believe that there's an allegation she's currently pregnant.
That's not. I have down that the defendant and victim have a child in common. Victim has another child. Defendant is married to another woman, and victim reports the defendant and victim had a casual relationship that resulted in pregnancy.
Got it. That resulted in pregnancy.
And I certainly understand the concerns of the court, Judge, but to be fair, a $1 million bond is traditionally reserved for homicide cases, Judge. In this case, in this particular case, Judge.
Not in this county, but go ahead.
Thank you, Judge. Respectfully, Judge, we're just asking for a fair, reasonable bond that will ensure that this young man comes back to court, which I'm confident he will, number one. And number two, ultimately, that they don't have
Counsel,
any communication.
Have you read through the discovery thus far?
Very briefly, and I've spoke with his
All right.
counsel as well.
So I'm not saying that I may not look at it, but based upon the allegations that I have at this point, I would consider this individual to be a high risk to the community, given the circumstances. I think when you look through everything, then maybe there might be an argument where the court would change its mind. But with what I have in front of me at this point, I think that the bond is appropriate.
Would Your Honor consider a 10% provision?
No, at this point.
Thank you, Judge.
I'm going to tell you, go look at all of the discovery, go through it. And I'm sure at the next hearing, you're going to raise some argument again, and that's fine. I'll hear it. And if you want to file a written bond request, we'll be more than happy to hear that. But based upon what I'm hearing right now, I think that this bond is appropriate given the nature and injuries and what this court would perceive the defendant as being a risk to the community.
Absolutely.
Okay, so you hear that based on the charges, the circumstances, that he believes that this defendant is a risk to the community. So the bond will remain at $1 million. You heard his attorney ask for a 10% provision. Can he just put up, can we do 10% of that bond, which will be $100,000? And he said no, he's not going to do that now. But he is giving the attorney the opportunity to go and review the case and then file a motion that will then be taken up at a later date, where they have a very specific motion to deal only with that person at that point in time. All right, so that's the first video. And once again, that's dealing with bonds. Let's jump back over here. And let's do a couple searches here while we're preparing for the next video we'll jump into. The next one will be a police officer that's assaulted by a young woman in a shopping mall. All right, but before we jump there, are there any questions or comments that you all have about bond in that situation? All right, in the situation of domestic violence, sounds like it was a baby mama type of situation. It was a person who he is married to someone else, but he has a child either before this marriage happened or a child during this marriage with this other young lady. All right. And I guess maybe she was not pregnant at this point in time, or they weren't very clear. And once again, they are very early in the case, and that will be fleshed out first thing, because those types of facts are the ones that you want definitely to be clear before you get in front of a jury, because certain facts don't play out well in front of a jury of 12 people. All right, and that's the key thing that we all have to keep in mind with this advocacy alchemy. All right, when you're making this soup, all right, you have the facts of the situation that you're dealing with, and you have the law, and then you have these 12 personalities out here too. If you want to make a good mix, you have to find the proper facts for these 12 people. So it's in your best interest to be able to come up with a good theory of the case or a good defense for what the state is trying to bring. All right, so with that, let's move into the second one, and let's take a look at it and see what they're talking about here. Okay, so we have it here, pause here at the end of the video where we can see what the charges are. We have simple assault on a police officer, and this happened, this is from Midwest Safety. The name of this video is Here's Why You Don't Punch a Cop, number 2. All right, and this is a video from a few months back. It's an interesting one. All right, first of all, this video doesn't tell you where it's from, but they give you a few pieces of information that we can use to do some legal research on. All right, so first of all, you see that this case has this information. It says simple assault. You see that code there off to the side? 2903.13. All right, we can type in just this information. It's going to tell us what state this is in, okay? Let's see what it pulls back. Ohio. All right, so we know this is in Ohio just based on giving that exact statute number and what this code is. It pulled back. This is probably Ohio you're talking about. It says in Ohio, simple assault is defined under Ohio Revised Code section sign 2903.13. It involves knowingly causing or attempting to cause physical harm to another person or their unborn child. Simple assault is generally a first-degree misdemeanor, which can result in penalties up to 6 months in jail and a maximum fine of $1,000. All right, certain circumstances can elevate the crime, the status of the victim. For example, the victim is a police officer. The assault charge can be elevated to a felony. So it goes from being a misdemeanor to a felony if you have assault on a police officer. All right, I'll leave that part up. Let's jump here to the beginning of the video. And once again, these are interesting. No one is seriously hurt in this video, anything like that, okay? But let's watch and let's keep in mind that this type of situation happens more than you think, okay? And I say that meaning that if you're going into the law and you're going to be representing people, you'll realize that over the course of your career, there'll be many times when people have instances where something happened with the police, all right? And you have to jump into action and save people from the most worst results. Okay? All right, let's listen to this and let's see what we have here. And here's why you don't punch a cop.
Punching a cop in the face is never the answer to your problems.
You're going in cuffs in 3 seconds, I promise you.
Put me in cuffs. Right now. My back.
You gotta give him space, okay? Give him space.
Because he fucking does this every single time. It's crazy. Where am I gonna go?
9-9. It's
Are you here?
okay. I'm taking care of it. We need you to stay away from here. What was going on?
Okay, so you see that there's some sort of argument going on back and forth between a male and female. All right, everyone. All right, here's a bit of common sense advice. It's never good to fight out in public. Okay, if you have a disagreement, handle your disagreement in private, and therefore you're not here, as we all see, in public, about to get arrested. That's the worst place in the world to be, is somewhere where everyone can always go back and see. But let's jump back in.
In the first place, what's happening?
It's so dumb. How do you offer to pay for somebody to buy somebody something and then buy it for them and then get mad at them out of nowhere and then take it back and want to return it? If you don't buy it first, you never should have. You should be fine. Who cares? Then I just won't care back. But then when he got mad, it's just some fucking normal to get over here and then I can take these saying he doesn't see the narcissist.
I know you're upset.
You order you being stupid woman. You mad because you don't fit?
Okay, so we understand what the situation is. So apparently something was bought as a gift for her. Something happened, and then he took the gift back and returned it to the store. So that's what this public breach of the peace is all about. All right, so let's see.
What this shit has wall?
Back up. Go ahead. You're gonna go. You're not gonna act tough. You want to go in handcuffs? Yes. You're not gonna act tough, okay? So unless you want to go in handcuffs, stop it. You're gonna exit the mall now. Do you understand?
Off with your eyebrows. Calm the down, okay? I'm calm. He didn't do anything. This is my fault because he was pissed off because I was running this cross like he talking for me. And he's mad at me for looking over a little argument.
Okay, so I have looked up the trespass law in Ohio. All right, criminal trespass is defined under the Ohio Revised Code, section sign 2911-21, or not dash, but point 21. A person is guilty of criminal trespass if they, without privilege to do so, knowingly enter or remain. That's where we're at right now, everyone. We're on the remain portion. On the land or premises of another. She's being escorted out of a mall at this point in time by the police. So that means that her permission to be there has been revoked, and they have asked her to leave, and she refused to do so. It says this includes entering or remaining on the land that is restricted to certain persons, purposes, modes, or hours, or where notice against unauthorized access is given by actual communication, posting, or fencing. All right. That second portion of this law is talking about when you have certain signs posted on certain land, or what if it's a public park that has certain hours when people can be there. All right. Trespass is based on license. You know, it's based on you having the permission to be in a place. Sometimes you're given permission by being invited there by the person who owns or rents the place. And sometimes it's sort of a general invitation to all. If it's Dillard's, JCPenney, Abercrombie Fitch, in these other places, you know, a mall at large, it has a general invitation to the public for everyone to come in and shop there. Now, if you cause problems and you're asked to leave, then your permission is revoked. And at that point in time, if you do come back again, the police can be called and informed that you do not have the permission to be on the premises. All right, let's jump back in.
I guess you're just gonna tell me like, come on, please. Like, I'm not mad at him, man. I'm not mad. I'm fine. You wanna? Hey, you ever watch Steve Bird? He was like Balloony. You ever see that? That's just really funny. He was just like Balloony. Like that's crazy.
Okay. It's always best to have as cordial of an interaction with an officer as possible if you're being escorted off of a premises, or if you're in a traffic stop due to an infraction or an alleged infraction. Be on your best behavior. Okay? All right, take this as a video of things not to do. All right? As you know, never assault or hit or batter a police officer. All right? Second, it's easier to be on your best behavior. Not cracking jokes on the officers as they escort you out. Not doing anything that could be taken as a threat. All right, we understand that, I mean, everybody, as we watch this video, she's not very imposing, all right? But still, even though the person is not very imposing, you don't have a right to hit the officers that are there simply doing their job. All right, let's continue watching.
So wait, you gonna return him? Please, leave.
You're not going back in the mall.
I'm not going back in this mall. When am I gonna go back in the mall? Oh. Well, I can't leave without him.
You can't leave without him. You're a grown adult.
No, I'm not. I'm not. You guys can tase me, you can shoot me, whatever.
It's not nothing like
Who cares? No cares. I'm not leaving this mall without him.
Well, you're not leaving with us.
Joey! Oh, now you're Joey.
You're gonna leave the mall, okay?
Watch out, bro.
You are going to leave the
Watch
mall.
out, bro.
You're gonna leave the
Watch
mall,
out.
or you're gonna go to jail. Do you want to pick?
I don't give a
You want to
Neither one of y'all. Joey!
You're gonna leave the mall, or you're going in cuffs in 3 seconds. I promise you.
Put me in the cuffs.
I will put you in the
Put me in
cuffs.
cuffs.
Okay.
Right now.
Are you serious right now? Put your hands behind your back. Put your hands behind your back.
Okay, so as you noticed, the video paused there. That portion was either redacted out when it was sent to the Midwest Safety, or they redacted it out for the purposes of, YouTube do not show violence or unnecessary violence. All right. Now, let me inform everyone that if you work in the justice system and you're dealing with criminal cases, or you're dealing with civil cases. If there's body cam footage that's ever produced, it will be unredacted. You'll see everything that happens there, and it will be the full unedited version, hours and hours of content. And many times you'll have to stipulate to, certain portions that are important for the trial. All right.
Serious? Don't move. You hear me? Don't move.
I don't give a I don't care. All right, thanks, bro. Thanks, Mom. I didn't know.
Stop moving.
I'm not moving, bro. If you're gonna shoot me, just shoot me then. Yeah. You got my glasses for me? Yeah. You got my glasses for me? The dog came? Thank you.
Yeah, it's fine.
You not okay now?
Hey, now you caught a felony. Good job.
All right. How long do you think I'm gonna be in jail?
All right, so apparently that was her mother there. It said mom at the bottom scolding her. So her mom didn't try to break in and stop the officers from whatever they were doing because she would be arrested also. All right. Her daughter was clearly in the wrong in that situation for throwing a punch. And I think he's going to come out and they're going to show him getting pictures of his face taken. So she actually punched him in the face.
For a couple months.
How did you do that? We have cars meet at Dillard's North as we were escorting this female out.
Thank you. Recall for still being 12:30 now. I don't know if 3 to 99.
Go ahead.
Stop. This male party involved as the deputies walked out.
Okay, you notice there she tried to act like she wanted to jerk away and run, and the officer had to catch her arm up and say stop. We'll go back so you can see that portion, but they're getting ready to get her in the car. And
We're still being 12:30 now. I don't know if 3 to 99.
Go ahead.
Stop. This male party involved as the deputies walked out.
He was involved in a verbal dispute with this female. I was escorting the female out. Deputies were with the male.
Okay. I'll be with the male then.
She's too busy dealing with you.
Yeah, I'm about to you guys are handcuffing me. It only takes one of y'all.
I'll be
Come
with
on
the
now.
male then. She's about to leave. Do we need anything from him?
Yeah, we'll keep him around for a minute.
Hi.
Okay, I'm up
What's up?
south and
Well,
the male.
she decided to punch me in the face, so.
Okay.
What did your radio? I'm out North Dillard's.
You like your job? All right. We'll use.
Don't look at me.
We'll use
Oh,
this here.
now.
All right. I'm gonna need you to relax.
Relax.
Okay.
They handcuffed my bag to me.
Okay. I see that. I'm gonna put her in your car since she's here.
Wake up, I'll be up yourself.
Cut her. She's
Oh,
wild.
don't cut my bag. No.
mean,
Okay,
she
then
just-
we need you to stand still then, okay? I'm not gonna go anywhere. All right.
You guys got her arms?
Yep.
Radio 1292.
I came down. She started getting lippy, so we were escorting her out of the mall. And then she decided to turn around and just cold cock me in the face, so.
Looks like right there, Fairmount. Locally, it's on the left.
We're almost done. Just relax, okay?
Thanks for the forerunner.
All right. You guys ready, my right? We're gonna have you sit down in this car over here, okay?
Okay, they have it.
Come on now. All right, have a seat.
Okay, so you heard the young lady say, none of you all have read me my rights. All right, understand that, you know, these little snide comments and things of that nature don't help you out in the end, okay? They help no one out. Your rights, the Miranda rights, are read to a person when there is an ongoing investigation to determine if something has happened, all right? Or, all right, so let's talk for a second here. When can the police handcuff a person, right? So you can be handcuffed, we all know, once you're under arrest, one. Number two, if there's a investigation. So say, for instance, there's one officer, 2 or 3 people in the car, all right? Usually they can wait for backup, or they can handcuff a couple of those individuals while they speak to another, all right? And the handcuff is only for the purposes of detaining a person for the officer's safety while they conduct either some roadside further investigation to what's going on, or to perform frisk of the other individuals, things of that nature, all right? So handcuffs can be used at various different stages, but usually if you're in handcuffs, you're probably under arrest, means you cannot leave freely of your will. All right, they haven't had to talk to her about anything yet because she's basically been caught on camera hitting the officer in the face. Now, I guess they actually could have read her rights if they had made it to the car, or if she had made any statements while they were walking, and the one officer asked her, why did you do that? Okay. That portion potentially could have been available for someone to try to suppress. All right. You have motions to suppress various forms of evidence because there's some issue with the evidence coming in. Basically, a person wasn't read their rights, knowing that they could have remained silent, and they didn't have to answer any questions being posed to them without having an attorney present to counsel them on how to answer those questions, things of that nature. All right, so let's continue watching.
Where'd she hit you?
There.
We'll take a photo of you.
Is your camera up in the front seat?
Yeah, it should be on the floorboard.
I've seen you know what happened up in the mall with the male and the female.
So I was.
She's under arrest for assaulting you.
Yeah, so I was upper. I was walking towards Diller to pick this up from Jake, and I heard the commotion coming from down in the center court. Looked over the railing, and all 3 other off-duties working were already with the situation. It just looked like a verbal argument, maybe a little scuffle between her and the guy. I couldn't tell because I was kind of looking over the railing. So I wanted to go down just to make sure they were okay, so I could call it in, everything. They were escorting the guy out, so at that point I assumed it was verbal. I didn't really get the story at all because I kind of got there late. So as they were doing that, she started getting all whippy with mall security and everything. She was being loud, so you're going to leave the mall too. So we're walking around, she keeps stopping, turning around. I'm like, you're going to turn around or you're going to go in handcuffs. You know, you have to leave the mall right now. So she starts walking, and she just swings around and clocks me right in the chin.
Okay. All right. So obviously she's under arrest for that.
Yeah.
Letting you know because we got him.
Yeah, I don't know what it's all these deputies except for what that situation.
Okay.
They were arguing over some bag with shoes in it.
finally got separated, got him calmed down. You need to go back to the other. She started the argument. Okay. Yeah, you're good.
And then.
Hey, Ben, I'm trying to determine.
Okay, so you see that as we get down to the end of this video, we have this officer here it said he's the shift supervisor. So basically his job is to, any incidents that happen, he has to show up. He has to get an assessment of what happened. And it may be his duty to either be the final sort of say-so on stamping off on the reports that come in for that day or for that shift. So he has to be not necessarily involved, but just he needs to be brought up to speed. He needs to be aware of all the incidents that happened during his shift in order to give that information back over to his superior the next morning or the next bullpen call, or whatever they call it in his jurisdiction. The morning call when they go over all the instances they had, have a head count on who's present for duties that day, so on and so forth. You also notice that there were people wearing the polo shirts, and not this woman here. All right, she's a female officer that was brought to the scene to deal with a female suspect. When a female is available, females will deal with female suspects. If one is not available at the scene, usually there'll be someone either at the jail, if possible. If not, then they will be seen to by a male officer with someone else present. Okay, usually, if at all possible. Okay, let's jump back and let's see what all happens at the end of this. And we have one more at the end of this, a whole separate video talking about something different. All right?
Can you just drop her at the jail?
Yeah, we'll probably just put her in a holding cell in the meantime. And then, we'll see how cooperative she is. And then if we got to throw her in a holding cell, we will.
Can you go to back up?
She's in my car. I'm going to take her to the jail.
She needs.
What do you want me to do?
Somebody's got to go back up Ben Bow because somebody's got to go take a traffic crash on the highway.
Yes. I'll go with Bow and then I'll be at the jail. Just get her info and get her set and I'll be back there shortly. All right, I'll go.
Search the female. So anyway, we're trying to escort her out. She's trying to turn around, walk the other way. She's telling her we need to leave. So he makes a decision. She says, "Go ahead and arrest me, wherever." She didn't want to. She's refusing all the wrong. So he makes a decision. She turned around. Oh yeah. She turned around. She clocked him. That was a great punch. The male. The female. I want to know, is there a domestic violence dispute between the male and the female? No. Okay. They're not, so we have him held upstairs. We need to know, can we release that male? Okay. All right, so she assaulted him up there, so we just need to know if he needs anything, if they're boyfriend, girlfriend, if they're domestic. Boyfriend, girlfriend, they do not live together. Gotcha. Okay, cool. Sounds like we got everything we need then.
All right, there's also another purpose. All right, based on the situation that's going on, sometimes that information is important. Are they domestic partners? Meaning, do they live together and share a household somewhere? Because of this type of incident, sometimes there may need to be a order of protection or whatever it's called in that jurisdiction. And let's take a look at that before we move on to the next one. Orders of protection, and they have different terminology of what they call these in every state. They call them orders of protection here, and they call them also they call them orders of protection also in Alabama. And Alabama is where I actually studied law at before coming back home. I think I remember them calling them the same thing there too. All right, in Ohio, there are several types of protection orders to safeguard individuals from domestic violence, stalking, and other threats. You have domestic violence civil protection orders. They call them CPOs. All right, protects family or household members from abuse. All right, can last up to 5 years and may include orders to stop abuse, grant possession of the residence, award temporary custody, and require counseling. All right, these all are filed in the Ohio Domestic Relations Court. Now they have also the dating violence civil protective order for individuals in dating relationships who are experiencing abuse, similar to domestic violence CPO, but specifically for dating partners. Man, they have a civil stalking protection order, and they have a civil sexually oriented offense protective order. Okay. Domestic violence temporary protective order for victims in a criminal case of domestic violence, granted as part of the civil case, of the criminal case. I said criminal, I said civil up here too, for victims of the criminal case of domestic violence, lasts until the case is resolved. And then you got criminal protective orders. All right, so it's interesting. All right, let's see what else we got here.
All right.
Yeah, I'll head back.
Yeah, I mean, you're on duty now. You're on overtime now.
Congratulations.
I have, how many minutes do I have left?
Thanks, Sergeant. Maybe like 5 minutes. Unbelievable.
This suspect, Lola, was charged with simple assault on a police officer. She is innocent until proven guilty in a court of law.
Okay, we have one more. Let's see. All right, this one's called Cops Save Family from Abusive Father and Things Take a Dark Turn. This is from Red Zone Watch, and this is from about 3 weeks ago. This is a interesting video, and we're going to look at this one in terms of a police search, incident to arrest. Okay? Now, this was in, where was this at? Did it say? I do not believe it told us where this one happened at, but this one actually had some very interesting content due to what was found during the search. All right, so you all watch this, and we'll watch it together. We'll pause, and we'll definitely give commendations to what was done right, and we'll point out some things that maybe were lacking, and so on and so forth. All right, you all hang with me, and let's finish this one up.
Well, I need you to turn around and put your hands behind your back for me, okay?
For what? Because you're going to be under arrest.
On March 7, 2024, officers were dispatched for an alleged physical domestic. Apparently, the caller heard a physical altercation break out between a young couple living next door. When officers arrive, they question the female victim and mother of 3, but the boyfriend is nowhere to be found until they exit the building.
Hey, what's up, bro? Hey, question for you. Is that your truck? Hey, we got some questions for you. We have all this in the well-being check. My partner just got some questions for you real quick, okay?
Yeah. What's your name, Michael?
Yeah.
Michael. So, like I said, I'm Officer Williams, this is Officer Nelson. We got body cameras on. We're here for a well-being check. A neighbor had called saying...
Okay. I do like how the officers, when they stopped him, they told him, they found out what his name was. They found out he is the person they're looking for. And they informed him, we have body cams on, and he's going into the situation of what they are looking for him for. Now they're going to start asking some questions, and this body cam that we're watching here, this young man, he does a very good job, and we'll stop and pause, and we'll talk about that as we listen.
that they were hearing an argument going on or anything like that?
Yeah, like 2 hours ago.
Yeah, can you explain to me what was going on with that, man?
No, my son was late off the bus and he was just arguing about that.
Your son was late off the bus and you're just having like a verbal argument about that and stuff like that. What was there to argue about in terms of the bus?
Like, I was trying to call the school and everything, call the first, what is it called? First student?
Okay. So you were on the phone.
Mm-hmm.
Were you arguing with Marsha or anything about it?
Yeah, earlier.
What was going on with that?
Nothing really, we was just arguing.
Just arguing?
It's a lot going on. I got another girlfriend.
Okay.
So we was arguing about that and everything.
Right.
Did she just find out about that?
No, she been knew about that.
Oh, okay.
We was just had a little altercation, that's all.
So she was saying that that you might have took her phone. Is that true?
No, I got my phones.
No, you just keep your hands out your pockets for me. It's just for our safety, right?
Yeah.
Yeah, but it's just for our safety.
Okay, so remember, the officers have already been here talking to the girlfriend, so they have sort of a rundown of the story, and they're trying to piece everything together, asking him what they know so far, and trying to see what his response is to their questions. Now, he did inform him to definitely keep his hands out of his pockets just for their safety, because they don't know if you're reaching for something or not. Always, if you're dealing with interaction with the police and you seem to be a suspect or you've been stopped for a reason, keep your hands where they can be seen. All right? Now, I'm not saying that you actually have to put your hands in the air unless you've been told to do so. But keep them out where they can be seen. Don't make any quick movements, and interact like an average person. Okay?
So, you didn't worry, because she said something along the lines of somebody's phone got taken, and she walked over to get your phone, you drove away with the phone, or anything like that. That doesn't ring anything like that, even?
No, I didn't have her phone. I didn't have her phone, though.
No, you didn't have her phone at all?
No.
You didn't touch her phone at all or anything like that? Did anything get physical?
No.
No, nothing got physical or anything like that?
No.
Because she was like, it was just being told, like I said, I'm just reiterating what I heard, right?
Yeah.
That you kind of pushed her away a little bit, just
like when I was trying to leave out, yeah.
Right. So you kind of just, she said she was like blocking the way.
Yeah.
You were trying to leave out.
Mm-hmm.
That's your right to leave, right? And then you just kind of left, and you kind of pushed her face a little bit or something like that.
No, I just pushed her out the way.
Just pushed her
face.
Could you explain? Did you push like her upper body, her lower body, or
I just watch out.
Like a shoulder nudge or something like that? No. Okay.
Where do you push? I just I'm gonna leave it now.
Okay. Where do you think your hand touched her, if it did?
Like in the chest.
The chest area. Okay. Anything else? Did you put your hands on her any other way?
No.
Okay. I got you.
Okay. Well, I need you to turn around and put your hands behind your back for me, okay?
For what?
Because you're going to be under arrest. Stop, police!
Okay. All right. So you see, we got action. As soon as he told him, we need you to turn around and put your hands behind your back, this officer actually has hands on him, but he was off to the races very quickly. All right. Once again, this is a very dangerous situation once a person runs. I never advise anyone to be in a situation where they're running from the police. All right. Hopefully you're never in that situation where you have to make any decisions about whether you need to run from the police or not. But it's never the best decision to run from the police. All right, let's see what happens here. And once again, no one is injured in this video, but this is for thought and for conversation and for the purposes of the lecture. All right, we're talking about search incident to arrest. And we'll type in and we'll find out, because I don't believe we know exactly where this happened at, but we'll just, we'll look at several different places and what the law is currently on search incident to arrest.
Stop police! Stop police!
Come on, man.
Come on, dude.
Oh, come on.
Hands behind your back, right now. I am. Put your hands behind your back. You're not fighting.
I'm not.
We're in the back. All right, let's get some cuffs on.
Come on, bro.
Dude, what was that? Come on, man. I got it, Duncan. All right, man. I got it. I got it. Right there. 1 second.
Wow. I ain't resisting no more, bro.
I know, man. All right, bro. Let's get up, man.
All right, thanks, man.
Where we right?
Yeah, do all that?
Yep. Knees in the chest. Put your knees in your chest, man.
What's going on?
We're trying to stand you up. Look at these guns here.
Okay, well, had some buffering going on or something. All right, but that's a good place to pause for a second here, anyways. But you see that this guy, he ran and he made it to this backyard, and they caught him before he was able to jump over this fence. All right. At this point, everyone's huffing and puffing. Adrenaline is running very high. All right. You heard him say once he was on the ground, "Hey, I'm not resisting anymore." All right. So even though he says that, these officers don't know what could happen next. So understand that once a person is in this zone of the interaction, they've gone beyond the usual. All right. At this point, the police are ready to use intermediate force. That means stun guns, pepper spray, all the things one step down from lethal. All right. You have to keep that in mind. You have to know the state of play for the situations that you are in, or your client, or a family member. All right. If you're ever assessing or watching video of this nature and trying to make assessments on what should happen next, understand the state of play.
That's dumb.
Yeah.
Come on, man. What you running for us for?
I don't know. What am I gonna arrest for?
Let's go, man.
What am I gonna arrest for though?
Domestic battery.
What? Come on, man. You do better than that. You pull my pants off?
Man, we got you, man. You're fine right now. Hey.
It's coming down. Your pants. It's coming down, bro.
I get it, man, but I don't need you digging in your pants. I know what's in your pocket. I ain't searching you. Come on, man.
It's about my kids.
We're not saying goodbye to nobody right now, man.
All right.
So walk to my squad car.
You're glad you're out.
Hey, Buster, you knew you weren't jumping that fence. Come on now.
Huh?
You have injuries?
Nah. Are you sure? Yeah.
All right, man.
It's like, man, it's hurting my arm, bro. I'm not gonna run no more, okay?
Yeah, but I know, man. You shouldn't have ran the first time.
It's bad enough that the guy attempted to flee, but what the officers are about to find on his body is going to make the situation a whole lot worse.
All right, listen to these
All right, man.
proper
Spread your stance for me.
introduction to him. All right, so we're at the point now where the search is going to happen. All right, a search incident to arrest. Let's look that up. All right, you always hear about different searches that can happen, okay? You have different circumstances that allow the police to search your person or your property and not be in violation of the Fourth Amendment. All right, when you have certain exigent circumstances, then the police have the ability to search even without your permission. One of those times is a search incident to arrest. Let's see what it pulls back here. And take this off. Okay. All right. So a search incident to arrest, a legal overview. All right. A search incident to arrest allows police to perform a warrantless search of an arrested person and their immediate area. This is an exception to the Fourth Amendment's warrant requirement, aimed at ensuring officer safety, preventing escape, and preserving evidence. So you see they have a three-pronged reason why the police can search you without a warrant if you're being arrested. All right, they have several of the cases here. We learned about these old cases in law school. And this one had not gone up yet by the time I was in law school, but we had heard some rumblings about this case. All right, so you got Shamel, you got Robinson, you got Gant. All right, and you have this Raleigh v. California from 14. All right. Look at the rulings on these cases, though. So in 2014, the Supreme Court ruled that police must obtain a warrant to search the digital contents of a cell phone found on arrestee. Distinguish cell phones from other containers due to the substantive privacy interests involved. All right? So remember that. Remember this Raleigh v. California. This is going to be important here in just a moment. Okay? All right. The scope and limitations. All right. The search must be limited to the arrestee's person and the area within their immediate control. Your immediate reach. Is this in their close reach? So basically, one of these can allow the officers to search within the immediate area of where the person is. All right, this includes any items or containers within reach that contain weapons or evidence. All right, protective sweeps. Officers may conduct a protective sweep of the area to ensure their safety and the safety of others. This is limited to areas where a person could be hiding and must be conducted quickly. All right? Time consideration. You can't come back 2 days later and say, okay, well, now we're going to do our protective sweep. It needs to happen within a very close time period when a person is detained. Vehicle searches. A vehicle can be searched incident to arrest if the arrestee is a recent occupant and the vehicle is within their immediate control. This search must be contemporaneous with the arrest. Happen at the same time, contemporaneous. Exceptions, cell phones and breath and blood tests. All right, doesn't that kind of make sense? Your breath and blood is something that's inside of you. All right. Sometimes it takes something a little bit more to take those things away from a person. Your cell phone, it's really and truly a black box that you have to put a code in to get inside of, or you have to show your face, which is a biometric lock or biometric key to your phone's lock. All right, so those two things are not allowed as a search incident to arrest. All right, let's jump back in.
But just need you to spread the stain for you. There we go. All right. What you need 2 phones for?
That's my old phone and my new phone.
Oh, okay. I mean, you got anything on you that's gonna stick me, stab me, poke me, hurt me in any sort of way?
No.
Yeah, it's not needles, drugs, anything. Alright, man. You got nothing around your waistband or anything?
No.
Alright, man.
Probably down here.
What is this? What is this right here?
Yeah.
That's a gun?
Yeah.
I felt it, man. That's what I'm saying. I felt it, so can't tell me what it wasn't. No.
I'm going over there.
I know, man. I know you're not.
Yeah, I got it, bro.
Come on, man. You knew better than that.
Okay, so you see, once again, this is why this instance right here is exactly why this video is here, to show you that everything can take a turn. Both sides were armed in this situation. This man who was running was armed the whole time. All right, that gun was in his waistband, had dropped down in his underwear to his crotch area. All right, the officer found it only because of this search before he puts him into the car. Defendant is, he's going to make his claims on this weapon. Now, he should have probably told the officers he had this weapon sooner and potentially disarmed himself sooner to make the situation even safer for himself. All right, but let's continue forward because there's some other issues here also besides just a weapon being found.
Is it loaded?
Maybe.
Hey, anything else?
No.
That's sure, man.
Yeah.
Thank you for not grabbing that.
I don't want to grab it.
It would have been dangerous if you did.
Come here.
It's okay. Right over there. Face my squad car.
Hey, they don't need to.
Man, come on, bro.
You don't want your kids.
All right, so you hear even the officer saying it would have been dangerous if you would have reached for that gun or you would have pulled that gun out. All right. Now notice the search is going to be the search, which originally was very cursory, meaning it was a quick search, is now going to become more intense to make sure there are no other weapons or things hidden. And I ask you all, how do you feel about that? Is it reasonable that the search will become more intense after a weapon was found that was not freely given up? Tell me what you think. All right, let's jump back in.
Ain't seeing this, man.
It's not my kids. I don't got nothing else, bro. I promise.
All right, man. I just got a search, man, for policy. I mean, you had a gun on me when I asked you got anything that's gonna hurt me. Keep your hands off me. You got it.
What else y'all think y'all gonna find?
We just got a search.
So notice he had on some blue jeans or some pants or something before that was sagging low, and now they got him outside. Them pants is off, completely off his legs. And they are searching everything to make sure that he has no more weapons on him or anything of that nature. All right, so you see, when you have interactions with the police, your dignity is the last thing on, your dignity goes below the safety of everyone else involved. Okay, so keep that in mind. Your dignity will go below in the order of things, the greater chain of being. Your dignity is much lower than the safety of the officers and everyone else present.
Well, after that, what else y'all think y'all gonna find out?
For policy, man. Yeah, do some search.
Do you have anything inside you?
Nah. Nothing else, bro. That's the only reason I ran from y'all anything.
I get it, bro.
All right, yeah.
Okay, he's in the grab him. Did I go through?
Get these shoes.
Oh, it's because it's defaced. Oh, it's scratched off.
Oh, that wonderful.
Right. You're sick.
Okay, so we see this is in Illinois. Now we can do some serious searching. All right, so if we're in Illinois, IL law defaced firearm. That's probably one of the worst places to have a defaced firearm at this time in the state of Illinois. But let's take a look at what the law is. We're in Illinois, and we can also look up all right, so we have two of our things here. Let's look up this defaced firearm. In Illinois, it's illegal to deface a firearm. This includes altering, removing, or obliterating the serial number or other identification marks on a firearm. All right, the relevant statute is in the Illinois Compiled Statutes, Chapter 720, Act 5, Section 24 through 25. The key points of the law. It's a Class 2 felony to knowingly or intentionally change, alter, remove, or obliterate the name of the importer's or manufacturer's serial number on any firearm. All right, Class 2 penalty is punishable by prison between 3 and 7 years, a fine of up to $25,000. Possession of a defaced firearm. It's illegal to possess a firearm that has been defaced. The state must prove that the defendant knowingly possessed the defaced firearm, but it does not need to prove that the defendant knew the firearm was defaced. So you only need to prove that the state only has to prove that the defendant knowingly possessed really a firearm. They don't have to know that the firearm was defaced. All right, they have a case on point, People versus Falco. All right, let's jump down to the fleeing. Fleeing and eluding police officers. This is against their Chapter 625, Act 5, Section 11-204. Fleeing or attempting to elude. Any driver who, after being given a visual or audible signal by a police officer to stop, willfully fails or refuses to obey. And this looks like this is talking about a car. Let's see aggravated fleeing or attempting. It says that's a Class 4 felony if you have aggravated. This is all about driving, causing bodily injury. Let's see fleeing on foot. I spelled my fleeing wrong, but let's see if they still bring it back. Okay. In Illinois, fleeing on foot to avoid arrest is a serious offense. It's covered in the Illinois Compiled Statute 720, Act 5, Section 31-1. All right, it's a Class A misdemeanor to knowingly resist or obstruct a peace officer in the performance of their duties. This includes fleeing on foot to avoid arrest. You got aggravated resisting. That's a Class 4 felony if the defendant causes bodily harm to the officer or if the officer is disarmed during the incident. Okay, so you see that the misdemeanor carries up to 1 year in jail, a fine of up to $2,500. The felony is 1 to 3 years in prison, a fine of up to $25,000. All All right. So with that, let's jump back in.
Serial number. Serial number scratched off? Mm-hmm. That's not good. Come on. You want to talk to us? Do you want to talk to us, yes or no?
What's your video? Talk to you about what?
Talk to you about the firearm or not? Hey, stay back, okay? Don't.
All right. So notice that the card that he had pulled out was simply a police Miranda rights card that they can read from. And the statement is fairly general. It's usually the same everywhere, and it just simply informs the defendant that they have, or the alleged suspect, the alleged defendant, that they have the right to remain silent, and that anything they say can and will be used against them in a court of law, that they have the right to an attorney, to speak with an attorney about their situation, and that they'll have the right to speak with family members upon reasonable request. All right? Also, it's important to notice that the Miranda rights are being read now because they want to ask him about, they want to ask some questions about that firearm. Okay? So they want to begin the process of investigating him now, or investigating the situation. And this is the part where I really want to commend the young man. Listen to how he asks the questions. All right? Once he gets the guy does want to speak to him, he asks these questions in the same fashion that a lawyer has examination while a person's on the stand. Okay? You have direct examinations and you have cross examinations. All right? Usually when you want someone to give you want them to answer a question openly, you ask an open-ended question: who, what, when, where, how. All right? On cross examination, you already know the answer you're looking for, so you lead the witness to the response that you want them to give. Now, sometimes they might not give the response that you're looking for, and at that point in time, you might have to accept the response as it's given. All right, but let's jump back into this, okay? Remember, they've read him his rights, his Miranda rights, and it looks like they skipped through that portion. They probably altered that out. And now they're going to, you've heard them ask, now, do you want to speak with us? And so that's where we're at. We'll wind it back a little bit and let's let them cook.
Want to talk to us? Do you want to talk to us, yes or no?
What's your video? Talk to you about what?
Talk to you about the firearm or not? Hey, stay back, okay? Don't come any closer than that, all right? Yep.
Y'all can't give her the keys?
Nope. You're not giving her any keys.
One of them?
No. Have a seat, bud.
Y'all can't give me the keys to my car?
We're working on it.
Okay.
Have a seat, bro.
Yeah, bro. I'm just trying to make sure what's going on.
I get it, bro. Just have a seat.
First of all, thank you again for not reaching for it. Well, it was stupid that you took off, right?
I wouldn't be nothing like that.
You know what I'm saying? So thank you for not reaching for it, and you're on spot, okay? Yeah. So the gun, obviously the serial number is Defaced, so you're never under charge with that. We're just waiting for your criminal history to come back. How long did that gun for?
Probably about 3 days.
3 days? Who'd you get it from?
I don't know his name,
Devontae?
Right. Is he Bloomington?
Yeah.
Okay. What's his last name?
Okay, so you notice that he's bringing out a notepad and he's going to start writing down some notes. The alleged defendant, the suspect, he says he purchased the gun about 3 days ago from a person named Devontae. All right, let's see what he has to say about Devontae and what other information they get out of him as they speak to him.
You know what it starts with? What does Devontae look like?
Dark skin.
Dark skin?
Yeah.
Alright. Where did you buy it from him? How much did you buy it from him for? 600. Okay. Where did you buy it from? Like, where were you at when you all met up to buy it?
I don't know the exact address, but Marbury Street.
Is it over there on Mulberry? Okay. Do you know if he lives over there? No. Do you know where he lives or anything? Did he drive or he was in a black car? He was in a black car. Do you know what the car was?
All right. Notice that he's asking all the proper questions. If you were on or if you were having a direct examination with the witness and you have a jury in the room, you want to ask these types of questions: who, what, when, where, how. And you just repeat the cycle. Look, he's asking when. When did you buy this gun? From who? Tell me what he looked like. What kind of car was he in? He's getting all of these kinds of questions. He's asking follow-up questions that link back to the question he just asked. So if something if the statement begins to sound kind of squirrely, he'll go back and he'll repeat back over the information. This is good police work. All right, this is building the case perfectly for the prosecution. They take that information and then they go right back over it again, hitting those same points when they have to deliver this case to a jury of 12 people.
It's like I don't know if it's real news, but it's like a Buick.
Like a Buick type there.
All right. So obviously the scratching off, right? When did you do that? What was the deal with that? Scratch off the serial number.
I never did nothing like that.
Okay. So I'm gonna let you. Are you familiar with guns?
Not really.
Okay. So I'm very familiar with guns. There's multiple serial numbers. Okay. So we're just gonna grab one of the other ones and run it. So obviously people scratch off serial numbers on any kind of item, especially pistols, right? We know them pipes usually come back stolen. Is that going to come back stolen once you find that second one?
I don't know.
You're not sure? Okay.
So
I never even checked that.
Okay. And you're a felon too, right? Yeah. Okay. I just want to make sure I heard the return right.
Let me get this correct here, Michael. You bought this gun.
All right. Now there's the other issue. So he's a felon in possession of a firearm. Let's look and see what that charge carries in Illinois. All right, and this term, how I put it in here, felon in POSS, that's pretty universal throughout the 50 states. That means felon in possession of a firearm. All right. All right, it says in Illinois, it's illegal for a convicted felon to possess a firearm. This offense is defined under the Illinois Compiled Statutes, Chapter 720, Act 5, Section 24-1.1. Unlawful use or possession of weapons by felons. It's unlawful for a person to knowingly possess any firearm or firearm ammunition if they have been convicted of a felony under Illinois law or any other jurisdiction. All right. Possession in different locations. The law applies to possession on or about the person's body, on their land, in their home, or at their fixed place of business. Look, so this law applies everywhere. If you're a felon, you can't be around weapons. You can't knowingly be around weapons. And when I say weapons, I'm talking about firearms. All right? Exceptions. The only exception is if the person has been granted relief by the director of the Illinois State Police under Section 10 of the Firearm Owners Identification Card Act. All right? It says the penalty is a Class 3 felony. All right, the basic sentence is 2 to 10 years in prison. It's a Class 2 felony if the offender has a prior conviction for a forcible felony. a felony violation of Article 24 of the Criminal Code, stalking, aggravated stalking, or a Class 2 or greater felony under the Illinois Controlled Substance Act. The offense is upgraded to a Class 2 felony with the sentence ranging from 3 to 14 years in prison. Look, it can be a Class X felony, which I believe is their highest level. All right? Possession of a machine gun by a felon is a Class X felony, which can result in a sentence of 30 years to life in prison. Possession of a machine gun. That sounds crazy. All right, let's jump back in.
Gun from a guy named Devontae, correct? You didn't scratch off serial numbers or anything yourself. So what you're telling us is when you bought this firearm from him, how many days ago did you say you bought it from?
About 3 days.
About 3 days ago. So you're telling me when you bought this gun about 3 days ago from this guy named Devontae, the serial numbers were already scratched on it. Is that correct?
Yeah.
Okay.
I'm gonna close. I'm gonna make a phone call.
Okay. All right, man. So my question is, how did you know Devontae sells? Like, when did that even come up?
I didn't.
So did he come to you and say, "Hey, I got a gun"? Like, how do you even know this guy?
Yeah. Like I was out with some friends. My
Okay.
friend Willie, and we ran into him, and he was saying like, "I want to buy a gun."
What's his name?
Willie.
Willie?
My homie is my friend Willie.
Your friend Willie?
That's who I know for sure, but I don't really know.
Do you know anything else about Willie other than his name? What Willie look like?
He a twin.
He a twin?
Yeah, he got a twin brother too.
What's twin brother name?
Charles.
Charles? Okay. And so about Willie, what is Willie like? How did Willie? Do you know how Willie knew, or Willie just mentioned it to you that hey, if you want to buy a gun, go to this guy Devontae?
No, we walked to the store.
What store?
Red and Blue.
Oh, nice.
We walked to that store, then on our way back, we saw the dude. And then the dude was in it, and then we walked to where Willie stayed at, and then that's when I got the phone call.
Okay. So yeah, I ain't really worried about.
All right, so you hear he basically got the whole story out of him, a story. We don't know if it's true or not, but he has some lead to follow up on. Go speak to Willie, go see if Willie can corroborate the story that's been given by Michael here, that's in custody, about this person, Devontae, that accosted them, saw them walking to the Red and Blue gas station, and asked them if they wanted to buy a gun.
These people, I just like to get guns off the street so that children like that, your kids, don't have to go through that, right? Because you already said yourself, I guess you don't want none of them going through the stuff you done had to go through, right? So that's why I'm asking these questions too.
Whether the man is telling the truth or lying through his teeth, a gun with a scratched-off serial number is never a good sign. In most cases, weapons with missing serial numbers are used for murders or other horrific crimes, so the suspect can consider himself lucky if the
Okay. Now, as I'm waiting on that buffering to come back, like it's, I guess, let me see what this is set to. Can't believe I'm getting that much pushback and issues with this. Man, y'all give me this enhanced bit rate. But while I'm waiting on that, take a look at this up here. Let me take this out of this mode. Might be running out of memory. All right, take a look at this here. You see where it says the date of when this happened. So this happened on March 7th of 24. Look, it's 4:46 in the afternoon. We know this is in Chicago now, but also we know by this time zone stamp, -6 hours. This is an Axon body cam, the 4th generation. And this is what officer is, 8689. Okay?
The gun comes back clean.
So we're trying to square away all the charges. Obviously, you're going to have several charges. We'll let you know each one. So far, you're on risk for domestic battery, resisting with injuries, felon possession of a firearm, a couple of UUWs and all that. So Unlawful use of weapon. It's just an abbreviated form of it.
I'm gonna set up. It's gonna come this way, alright? Have a seat on that bench.
Loosen it some more?
Loosen it.
Here, second.
Have a seat.
So with the pistol, obviously the serial number scratched off. When did you know it was scratched off?
I don't even know what you're talking about, bro. I don't even know what you're talking about.
Okay. Like the big scratching on the bottom of it?
You know?
All right, so I can't say one way or another, whether this person is telling the truth about what happened, but right now, I'm sure everyone, this is a perfect point to let any of your family members know that, hey, look, if you're ever incarcerated, you do have the right to remain silent, meaning that you don't have to answer any more questions until you have an attorney present. All right? At this point in time, the officers are going to continue to try to ask him questions until he asks for an attorney. And that's how it works. If you are involved in a situation, or if you have a family member, a friend, someone you know, or your clients, they will be questioned until they request for an attorney to be present. Okay? Now remember, you don't have to be able to afford an attorney to be given one, okay? You can refuse to speak to the police officers until you have an attorney present to talk about the situation. All right? At this point in time, everyone is safe. All right? This person is not going to be let back out until they see a judge and are given a bond. And the judge has heard all the evidence and either finds that there's probable cause for that person to remain detained or whether they should be released.
What serial number is on a gun? Like when you buy a gun, you know serial numbers on it.
I'm not saying you scratched it off, right? Okay, I think somebody else probably scratched it off, right? But all I'm trying to say is, like, when you got the gun, it was like, do you notice, like, oh shit, that's scratched off, or like would you notice? I know you did.
Oh, I still don't even know you could do. Like,
how much did you pay for the gun?
$600.
600? Holy!
What?
600 for pistol.
Is it gold plate?
It's got any tags for the pistol. $600.
See, well, I don't know.
Yeah. Who'd you buy it off? You know?
Bought off Devontae, correct? Yeah.
You got a last name on that?
Nope, but he said he's dark skinned, short hair. It's around $600. Lives near Oldbury.
You got a phone number?
Nope. He said you have a phone number.
It's not your name. You think Devontae obliterated the serial number, took it off?
Probably, yeah.
Because it's more likely stolen. That's why people do that. Is because they're hot. It's the only reason why you obliterate a serial number. Either it's hot or it's used in a murder or other crime. Is it okay if we search his phone?
Search it for what?
Devontae's phone number, evidence of the firearm being bought from Devontae.
Remember, we're watching this as a search incident to arrest. All right? During the search, before they arrested him, they found a pistol. All right? Now they're asking about how he bought the pistol, who he bought it from, and they're trying to track down that person that sold him the pistol. So they're asking about the cell phones. Can they search the cell phones? Remember, there's several different ways that a search can happen. We already heard that a search incident to arrest is not going to get you the permission to get into that cell phone based on Rowley v. California. All right, this says that the police must obtain a warrant to search the digital contents of a cell phone. All right, so that's why they're asking. Search based on consent. Excellent point. They're trying to obtain voluntary consent to search that phone now. All right, look, in Illinois, consent searches are a common type of warrantless search. So the Fourth Amendment guarantees that you'll be free of any searches of your person, property, and effects. All right. So that means your land can't be come on to without a warrant. They can't search your person without a warrant. They can't search your papers without a warrant. All right, let's look up what the Fourth Amendment says in full. All right, let's get the proper text. It says this is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Yeah, think about it. They wrote that hundreds of years ago now. A couple hundred years ago almost now. All right, so let's go back up here and all right, let's look at the voluntary search. Remember, consent. You can consent to a warrantless search. Consent must be given voluntarily and without coercion. Coercion means force. The person giving consent must have authority to do so. All right, that portion is there because sometimes a person in your house may not have the authority. They don't own the house. They don't pay the bills there. They don't have authority to give the police the permission to come in and search your property. All right, that's that situation that's talking about right there with that second sentence. The burden is on the prosecution to prove that the consent was voluntary and that the person was aware of their right to refuse. Aware of their right to refuse consent. All right, so that usually means that with this video here, they would put this video on to show that they had asked and it was voluntarily given. Now, as playing the other side here, if you're a defense attorney, you have not heard them explain to him that he can refuse. At least not yet. Let's see if we hear it. If we hear it even in passing, that makes the whole argument go away. All right, so let's see.
That's not up in the phone.
Where is it at? Okay. Devontae's phone number, evidence of the firearm being bought from Devontae.
That's not up in the phone.
Where is it at?
What you mean? Like, no, I didn't never have his, I didn't never get his phone number or nothing like that.
Yeah. Hey, we're not trying to make it seem like we're gonna go hook Devontae. We just want to make sure what you're telling us is accurate.
Yeah, but it's not up in the phone.
So again, are you giving us consent to go through these phones?
As far as what though? That's what I'm trying to see. Like,
It's like, well, it's your fresh air, so you just check for evidence of that firearm.
it's probably like pictures of it, but no.
All right. If not, we will go after the search warrant route, and it'll be a while before we get back to you.
Oh. Well, yeah. Yeah, I give y'all the consent to go through it. Like, what's?
All right. We'll try to get one of those forms.
After the suspect was booked and processed, he was charged with the following: domestic battery, resisting or obstructing a peace officer, domestic dispute, and aggravated unlawful use of a weapon.
Okay, so that's the end of that one. And everything froze up at the same time. Okay. I hate when they just do that. Okay. All right, let's go back here. All right, so that's the end of those 3 videos. If you hung in with me to the end, then hey, congratulations. If you're interested in studying law as a career, then all I can say is welcome. All right. It's interesting to know, well, it's not interesting, but it's good to know how to do research. All right. How to do legal research, how to look up the laws that are applying to the situations that are happening. All right. And why we do this is to show that you can look up the law in any jurisdiction, whether it be a federal law, whether it be a state law, whether it be some international law. All right? It's done the same way. Everything comes down to reading and researching what has happened before. All right? And what is the law in effect right now. Okay. I am Professor Ross. This is Advocacy Alchemy. I wish you all a wonderful night, and I will see you in our next lesson.